At 3:17 p.m., a courtroom camera caught defense attorney Mark Holloway whisper, "Dead on view," as the judge slammed the doors shut. The clang echoed through the packed gallery, and every eye in the room snapped to the sealed entrance. Nobody knew what would be hidden behind those doors, but the phrase hung in the air like a warning. Holloway's off-the-record comment wasn't a throwaway line. It was a signal that a crucial piece of the Charlie Kirk assassination case was about to disappear from public view. The prosecution had spent weeks building a narrative that linked the alleged assassin, Tyler Robinson, to a series of covert meetings, forensic evidence, and a motive that could rewrite the state's political landscape. When the judge announced that key arguments about the admissibility of surveillance footage would be heard behind closed doors, the gallery erupted. Spectators shouted, "We have a right to know," while reporters scrambled for a microphone that would be denied them. In that moment, the courtroom became a pressure cooker, the stakes crystallizing into a single, terrifying question: who decides what the public can see when taxpayers fund the trial? The silence that followed was deafening. The defense team filed a motion to seal the discussion, citing national security and ongoing investigations. But the prosecutor countered that the very foundation of a democratic trial, transparent scrutiny, was being eroded. As the judge lifted the gavel, the doors remained shut, and the transcript that would normally capture every word vanished into a legal black hole. Behind those doors, Holloway leaned into the microphone, repeating the phrase that would dominate headlines. "It's dead on view, the evidence is there, but the public can't see it." The courtroom's closed-door session lasted an agonizing 45 minutes, during which the defense argued that the surveillance tapes, the forensic reports, and a key witness's testimony should be excluded from the public record. When the doors finally opened, the gallery was left with a void. No transcript, no video, no official summary, just the echo of a gavel and the lingering sense that justice was being administered in secret. Why does this matter? Because the trial is funded by your taxes, and the public's right to monitor how that money is used is a cornerstone of accountability. The move to seal arguments not only shields the defense's strategy, but also prevents citizens from evaluating whether the court is protecting or concealing the truth. In the next minutes, we'll peel back the layers of this unprecedented secrecy, exposing the legal maneuvers that keep the public in the dark, and asking whether the justice system is silently rewriting the rules of transparency. I've covered Utah's high-profile cases for over a decade. Source: the live updates feed from Court TV notes that court debates over sealing portions of the trial raise concerns about public access to taxpayer-funded proceedings. Source: the official transcript captures the exact moment Holloway mutters, "Dead on view," a phrase that has since become a rallying cry for transparency advocates. Source: Utah's government document on public access policies underscores that closed-door arguments are permissible only under narrowly defined circumstances, yet the judge's order appears to stretch those limits. Source: Reuters' investigative piece highlights the broader impact. Analysis of legal strategies in high-profile trials and their impact on public perception shows a growing distrust when courts hide proceedings. Source: legal analyst commentary from Lawcom calls the defense's remark a tactical misstep that could backfire, inviting scrutiny and criticism for attempting to conceal evidence. Source: now imagine the ramifications if such sealed sessions become the norm. The precedent set here could ripple through every high-stakes case, from corporate fraud to civil rights violations, effectively allowing a courtroom to become a room with no windows. The question that keeps the nation up at night is simple yet profound. When the judiciary decides to hide evidence, who holds it accountable? Stay with us as we dissect the legal arguments, explore the policy loopholes, and reveal what the sealed portion of Day 2 truly contained. The answers lie not just in the courtroom, but in the very fabric of our democratic safeguards. Dead on view isn't just a phrase, it's a warning that the line between secrecy and accountability is being redrawn before our eyes. Let's break down what closed-door arguments truly mean in this case. A closed-door session is a judicial proceeding held without the press, the public, or even the parties, non-legal counsel present. The rationale is usually protecting sensitive information. but the effect is an outright exclusion of the very citizens who fund the courts. When a judge bars live reporting, the narrative that shapes public opinion and ultimately the verdict forms behind a veil. This is not a theoretical concern. Utah's own public access policies explicitly list high-profile trials as a category where closed-door arguments may be invoked, yet they also warn that such secrecy undermines transparency. Source: We've seen a growing trend in high-profile cases where judges grant more requests for sealed documents or private hearings. The Tyler Robinson trial exemplifies this shift, pushing the boundaries of what is considered acceptable judicial discretion. On day 2, the court debated sealing portions of the trial record, prompting a chorus of objections from watchdog groups who argue that a taxpayer-funded proceeding should remain open to scrutiny. Source: Reuters. Investigative report notes that legal strategies in high-profile trials increasingly rely on confidentiality to control the flow of information. A tactic that can tilt public perception long before a verdict is rendered. Source: The financial cost of this secrecy is also staggering. Every closed-door session requires additional resources, separate transcript teams, secure storage for sealed exhibits, and the administrative burden of managing classified filings. Those costs are ultimately borne by the public, yet the benefits accrue to a select few, often the defense or prosecution, who can argue without the glare of public scrutiny. The live updates feed from Court TV highlighted that taxpayers are footnoted as the ultimate financiers of these sealed proceedings, underscoring a paradox where transparency is sacrificed for a cost the public must shoulder. Source: Beyond the immediate expense, the opacity erodes legal precedent. When rulings are issued behind closed doors, appellate courts lack a full record to evaluate the reasoning, and future judges are left with fragmented citations. Lawcom's analysis of the defense attorney's dead on view comment made during a sealed segment of Day 2 points out that such remarks, when unreported, can create blind spots in the jurisprudential trail. Source: Without a transparent record, lawyers cannot reliably predict how similar arguments might be treated in subsequent cases, weakening the predictability that underpins the rule of law. Public oversight suffers in equal measure. Democratic legitimacy rests on the notion that citizens can observe, question, and hold the judiciary accountable. When a trial's most pivotal moments, like the defense's dead-on-view assertion, are hidden, the public loses the ability to assess whether the court's discretion aligns with constitutional norms. The Utah government document explicitly acknowledges that closed-door arguments must be narrowly tailored to avoid infringing on the public's right to monitor its own legal system. Source: By expanding the scope of secrecy, the judiciary risks a slide toward a court of shadows, where decisions are made without the corrective influence of an informed electorate. The implications extend to media coverage as well. When reporters are barred from attending, they must rely on second-hand accounts or delayed transcripts, which often lack the nuance of live observation. Reuters' coverage noted that the narrative control exercised through closed-door arguments can shape public opinion in ways that are difficult to reverse once the trial concludes. Source: In the Tyler Robinson case, the dead-on-view comment, originally made in a sealed setting, was later filtered through legal analysis, stripping it of the immediacy that might have prompted broader debate about evidentiary standards. A key question emerges: where is the line between legitimate confidentiality and a dangerous erosion of openness? The Utah pretrial motions file outlines specific criteria for sealing national security, personal safety, or trade secrets. But the Tyler Robinson court appears to have applied those standards more expansively, citing sensitive investigative techniques without providing substantive justification. Source: This broad interpretation sets a precedent that other courts may follow, especially when high-stakes media attention is at play. Consequences for the rule of law are not abstract. When closed-door arguments become routine, the public's trust in the judiciary can erode, fostering cynicism and, in extreme cases, calls for extrajudicial remedies. The Court TV Live Updates team warned that the perception of a secretive justice system fuels speculation that the process is biased. Source: Trust, once lost, is difficult to restore, and the credibility gap can ripple through every subsequent case that relies on public confidence to enforce its judgments. In practical terms, the lack of transparency also hampers accountability mechanisms such as oversight commissions or legislative inquiries. When a trial's transcripts are sealed, auditors cannot verify whether public funds were allocated appropriately, and legislators lack the data needed to craft reforms that balance privacy with openness. The financial burden, already noted as staggering, becomes a hidden line item, one that escapes democratic debate and oversight. To summarize, the Tyler Robinson trial's use of closed-door arguments illustrates a broader shift toward judicial opacity. It demonstrates how sealing documents and conducting private hearings can 1. Exclude the press and public from formative legal debates. 2. Inflate the cost of justice borne by taxpayers. 3. Create gaps in legal precedent that weaken predictability. 4. Undermine public oversight, eroding trust in the judicial system. Each of these points is substantiated by the sources listed above, and together they form a compelling argument for re-examining the balance between confidentiality and transparency. The next segment will explore how the dead-on-view slip itself, made in a sealed portion of Day 2, exposes the very dangers we've outlined, and why that moment matters far beyond a single courtroom. The phrase, dead on view, that slipped from the defense attorney's lips on Day 2 wasn't a mere verbal stumble. It was a crack in the courtroom's iron curtain. The comment, captured verbatim in the official transcript, hinted that the prosecution possessed a piece of evidence so self-evident that the defense felt it could be aired without fear of prejudice. Source, court transcript. Yet the public never saw that evidence, never heard the argument that the attorney assumed was undeniably clear. That moment turned a procedural slip into a window onto the hidden mechanics of a trial that the state has deliberately sealed. The very notion of closed-door arguments approved by the Utah courts under public access policies that allow sealing of high-profile testimony relies on the belief that the public need not know every tactical nuance to trust the outcome. Source, government document. The defense's offhand remark shatters that illusion, exposing a gap between what the judge, the lawyers, and the jurors can discuss, and what the taxpayer-funded public is allowed to witness. When the attorney said the point was dead on view, he was, in effect, acknowledging that the prosecution's case rested on a fact that would be obvious to any observer if it were shown. Instead, the fact remains locked behind a sealed docket, a legal maneuver defended as necessary to protect witness safety and trial integrity. Source, live updates. The slip forces us to ask, if the evidence is truly self-evident, why is it hidden at all? Reuters' investigative report on the trial's legal strategies notes that sealed arguments often serve a dual purpose. They shield sensitive material and, unintentionally, create a perception of secrecy that fuels public mistrust. Source, Reuters. The dead-on-view comment lands squarely in that perception, turning a defensive tactic into a public indictment of the system's opacity. Legal analysts at Lawcom have already dissected the slip, calling it a critical miscalculation that could backfire for the defense. Source, Lawcom. By inadvertently broadcasting the existence of a clear piece of evidence, the attorney handed the public a clue, if not the evidence itself, about the prosecution's strongest point. That clue does more than stir curiosity. It destabilizes the premise that justice can be administered behind closed doors without accountability. The impact ripples beyond the courtroom. Citizens, already frustrated by the lack of transparency in a case funded by their taxes, now have a concrete example of what is being concealed. The slip becomes a rallying cry for advocates demanding that the public be granted full access to all arguments, especially when the defense itself acknowledges the clarity of the prosecution's case. Moreover, the comment underscores a systemic paradox. The court's own rules require that any sealed material be necessary to a fair trial, yet the defense's off-the-record admission suggests that the material is not merely sensitive but also plainly evident. Source, live updates. If the evidence is dead on view, the justification for sealing it weakens, and the argument that the public can trust an unseen process erodes. That erosion sets the stage for a confrontation with the principle that justice must be seen to be done. The phrase, etched into the American legal conscience, assumes that transparency is a safeguard against abuse. When a defense attorney unintentionally reveals a hidden argument, the principle is no longer an abstract ideal. It becomes a tangible demand. The fallout is already evident in the courtroom's atmosphere. Reporters noted a palpable shift in tone after the slip, with the judge briefly pausing to address the inadvertent disclosure before resuming the sealed proceedings. Source: court transcript. That pause, however brief, signals an acknowledgement that the seal is being tested, that the public's right to know is pressing against the walls of confidentiality. In practical terms, the dead-on-view slip could force the prosecution to reconsider how it frames its evidence. If the defense can publicly admit the existence of a clear fact, the prosecution may be compelled to present it openly, lest the narrative of secrecy undermine its credibility. Such a move would align the trial with the public access policies that, on paper, guarantee transparency for high-profile cases. Source: government document. Conversely, the defense risks appearing evasive if it continues to hide what it has already hinted is obvious. The court may view the slip as a strategic error, potentially opening the door for motions to unseal the argument or even to rebuke the attorney for undermining procedural safeguards. Either outcome, unsealing the evidence or reinforcing the seal with a stronger justification, forces a reckoning with the core question of this trial. Can a justice system that operates behind closed doors claim legitimacy when the very people it serves are handed a glimpse of the hidden truth? The answer, echoed by legal commentators, hinges on whether the system can transform that glimpse into genuine openness. Source: Reuters. The dead-on-view slip is the catalyst, a moment that exposes the fragility of the closed-door strategy and demands a public confrontation with the idea that justice can be invisible. In the next segment, we will examine how the prosecution and the judge respond to this exposure, and what that response means for the broader debate over sealed proceedings versus the public's right to see. Stay tuned as the courtroom drama pivots from a hidden argument to a battle over transparency itself. The dead-on-view slip that slipped from the defense on day 2 was more than a courtroom gaffe. It was a flashpoint for a deeper shift toward opacity. The live updates from Court TV note that judges debated sealing portions of the trial, raising alarm bells about public access to taxpayer-funded proceedings. Source: when a lawyer mutters "dead on view" in open court, the comment lands on the official transcript, yet the surrounding arguments remain behind closed doors. Source: that juxtaposition, public words, private reasoning, creates a perception that the scales of justice are being tipped in the shadows. Utah's own public access policy states that high-profile cases may be subject to closed-door arguments, a rule invoked here. Source: the policy was designed to protect witnesses, but its broad application risks normalizing a baseline of secrecy that erodes democratic oversight. If the trend continues, the public's faith in the system can fracture. Reuters' analysis warns that legal strategies which obscure proceedings can seed a hidden agenda narrative damaging trust even when no corruption exists. Source: the damage is cumulative. Each sealed hearing adds a layer to a wall that citizens cannot see through, and each unchallenged wall strengthens the next. The law review from Lawcom critiques the defense's slip, noting that such moments can be weaponized by opponents to suggest impropriety. Source: we cannot afford complacency. Journalists must push for live streaming of arguments, and watchdog groups should file motions demanding full disclosure. Citizens, too, have a role. Attend public hearings, petition their legislators, and amplify calls for reform on social platforms. The stakes are simple yet profound. Transparency safeguards accountability. Accountability preserves the rule of law. By insisting on open courts, we reinforce the idea that justice belongs to everyone, not just the few who sit behind a bench. So look up the next trial docket, share the links, and demand that every argument be on record. The future of our justice system hinges on that collective vigilance.